pleasure now to introduce to you someone who I rather suspect needs no introduction at all. William Cattan, who is Senior Partner at Sultan Al-Abdulla. William.
Thank you very much. And I don't see Bo here, but I was going to thank him as well because his comments, I think, set the table for some of the remarks that I'm going to make today. I will tell you up front what the key message I'm going to try to explain and convince you of, and that is the best way to avoid disputes among stakeholders in a project is to, as much as possible, align the interests of the stakeholders at the outset of the project. Aligning stakeholder interests means that parties are less likely to get into a dispute and more likely to have a successful mechanism for resolving that dispute short of formal dispute resolution proceedings. The clearest and best example of that in Qatar, and I'm going to limit my remarks to Qatar today, is the energy sector, which has been developed largely through the use of joint venture companies, also referred to as equity joint ventures. And I think there's a lot of lawyers in the room, so I try not to talk down about some of these legal concepts, but for those who don't. Sorry, that's our alignment and misalignment slide. The Qatar Petroleum, which is the national oil and gas company, essentially followed this equity joint venture structure where you have two companies that join together and create a new corporate entity. And they used this structure for developing the LNG industry. They selected strong international partners and they created joint venture companies here. They created joint venture companies with ExxonMobil, ConocoPhillips, Shell. This is a slide that's not 100% accurate. There have been some changes in the shareholding, but the idea is just to give you a visual representation of the establishment of a joint venture company with a Qatari and foreign shareholders. This is the model that has been pursued not only in the LNG sector, but in the other sectors of the energy industry here. And in particular, it's been interesting that even in the crude oil sector, where there used to be production sharing agreements, essentially a contract directly between the government and the party that was engaged to explore, develop, and produce petroleum, the Qatar Petroleum has moved away from the production sharing structure, and as of about this time last year, the largest oil field in Qatar is being operated, and the concession holder is a joint venture company between Qatar Petroleum and Total. So I'm going to now contrast that sort of positive story with a much less happy description of what is occurring in the construction sector in Qatar today. In Qatar today, the number of major construction disputes is enormous. There are disputes occurring at every level, between employers and main contractors, between main contractors and subcontractors, and between main contractors and other main contractors in contractor consortiums. On the government side and project owner side, there is a feeling that they have been embarrassed and taken advantage of by incompetent and unscrupulous contractors. And on the contractor side, there is a view that projects have been mismanaged, contract terms stacked against them, and payments unjustifiably withheld. I'm going to talk about problems that arise when the interests of stakeholders are not aligned. There are a number of examples I could use, but I'm just going to give one example from the contractor side and one example from the government or project owner side as examples. And I'll start with the contractor example. It's very common in Qatar for two or more construction companies to bid jointly for a project, and if they are successful, to enter into a contractual joint venture. The arrangement would look like this. And I just picked Ashkelon not because I'm trying to pick on them, but just as an example of a project owner, developer. The three contractors enter into a joint venture agreement among themselves. There's no company formed, just a contractual arrangement between the contractors. And it is generally the case that all three contractors sign the construction contract in their individual capacities. So what are the risks associated with this very common arrangement? Often there is no clear allocation of responsibility for management of the joint venture. When decisions need to be made by the contractors, who is going to make the decisions? Who's going to have authority to block decisions? And what happens if an individual contractor decides to block decisions and actions of the joint venture because they're trying to advance their own individual interests? In addition, often there are no clear allocations of responsibilities as to who is going to interact with the employer. There may actually be a contractually designated party, a main contractor, a lead contractor to interface with the employer, but another contractor in the consortium may decide to establish a separate line of communication with the employer. And often there is no clear allocation of responsibilities between the contractors for the scope of work. It's often the case that the joint venture agreements just say that all of the work is going to be done by the contractors, when in fact it is likely that some parts of the work are going to be done by one contractor and other parts of the work by another. And it is inevitable in this type of an arrangement, if there is a dispute with the employer, that the contractors will all start pointing fingers at each other, arguing about who is responsible for doing or not doing what they were supposed to do. Sorry, I stepped on my own punchline. The final issue I would mention is that there is, of course, the risk that one of the contractors is in fact responsible for the problems that arise. For example, you could wake up one day and find that your world-class publicly traded venture partner disappears overnight. That was brilliant. That's an extreme example, of course, but consider this. Your joint venture partner has gotten into trouble on another project with a Qatar government entity. Hostility starts to develop on the part of the Qatar authorities toward your joint venture partner. The lack of trust on the other project seeps in and adversely affects your project. We have seen that happen. Or what if you are a Qatari contractor, and you live and you will continue to live in this country, but your partner is a non-Qatari company who, if things get tough enough, is prepared to abandon the project and leave the country. That could clearly have an adverse effect on how the contractor consortium responds to problems if they arise with the employer. And we've seen that scenario as well. Finally, as a matter of law, under Qatar law, and typically as a matter of contract based on the employer's requirements, consortium members are individually liable, generally individually liable for all obligations of the consortium. And accordingly, unless you have a different agreement with the employer can enforce the entire scope of the contract against each of the consortium members. So you may have agreed in your joint venture agreement that you are responsible for MEP works and your joint venture partner is responsible for civil works, but if your joint venture partner disappears, like Carillion, or fails to reform, you could find all the fingers pointing at you for the full scope of work under the contract. So many of these problems can be eliminated or reduced if the contractors create a joint venture company. And let's look at that structure again. This is the structure generally, but this would be the structure with respect to a construction contract. The JV, in the construction context, you would have contractor 1, contractor 2, and contractor 3 create a new company. Now, I appreciate that creating a joint venture company may not be appropriate in all contexts. The companies that I mentioned earlier, the company that I mentioned earlier, Qatar Gas, was established to operate a long-term project, not to execute a single, say, several-year construction contract. There are also various practical impediments. For example, a contractor consortium is not going to want to expend the time and expense to set up a joint venture company before they have won the contract. And at that point, Ashgal says, I picked contractors 1, 2, and 3. How can I now sign a contract with another entity? But these impediments can be overcome. There's nothing, for example, that would prohibit an Ashgal from taking a different approach and issuing a tender that says, for example, if we select a contractor consortium, we require them to establish a joint venture company because we consider that a much more stable structure when there are multiple contractors performing a single contract. Obviously, you would have to have appropriate undertakings and guarantees from the contractor, but the point is that it is unquestionably the case that establishing a joint venture company reduces the risk of disputes over management of the joint venture. The shareholders need to agree up front the corporate structure, the management structure of the joint venture when they establish the company. A corporate structure reduces the risk of conflicting communications with the employer. The employer has only one party with which to communicate. The corporate structure also reduces the risk that a problem with one contractor will adversely affect the other contractors. An employer may insist on events of default in the construction contract that relate to the shareholders' parents, or the shareholders in the joint venture company, who have the actual technical capabilities. So, for example, if you had Carillion as one of the parties, you might not avoid a problem if Carillion disappears from the structure. But it should be the case that there would be a much more limited series of events that would happen at the shareholder level that would create a problem between the employer and the joint venture company. So, in summary, the equity joint venture structure brings into much closer alignment the interests of all the contractors as shareholders in a single company. This reduces the risk of disputes between the employer and the contractors and between the individual contractors themselves. So I'd like to turn now to lack of alignment arising from actions of an employer, and here's where Bo's comments were a good preview. Specifically, the contract terms used by some of the largest project sponsors in Qatar, including Qatar Petroleum, Qatar Foundation of the employer, and against the parties providing design, construction, or project management services. Some contractual provisions are so burdensome or so disconnected from actual practice on a construction site that, as a practical matter, they can't be complied with. There is a history to this that I think is relevant. Years ago, the sponsors of major projects in Qatar, and let's use QP as an example, Qatar Petroleum, did not have substantial in-house capabilities. So they prepared contract terms that placed much more responsibility and risk on the contractor than was market practice. I believe, at the time, those sponsors of major projects in Qatar understood that doing this would increase the cost of the contracts it entered into. They would need to compensate the contractors for the risk allocation, and they were willing to do that because they didn't have in-house capabilities to share the responsibilities and the risk. Similar approach actually took place with respect to the project financing of projects in the energy sector, where initially at least Qatar Petroleum didn't have cash on hand to build the facilities it needed to build. Later on in the development of the LNG industry, they did have the cash and they didn't need to project finance their projects. It was more expensive, it was more timely, but they required more time. But they chose to take that approach because you had a financing and project contractual structure that would be reviewed by lawyers, by commercial people, and they would have essentially a market check on the structure and confidence that the structure was robust. But what has happened over time, to come back to the construction context, is that the cost implications and the risk allocations embedded in the standard form documentation here, or at least a lot of it, have been forgotten. And today, many of the government project sponsors seek to place a disproportionate risk onto contractors while also expecting market pricing from those contractors. Further, the contract terms are often imposed on contractors through a tender process that does not permit meaningful negotiation. So, what happens in those circumstances? Contractors sign the contract they're given, containing terms they can't or won't perform, at least in full. Bo, I think, mentioned one of the examples, which is the notice requirements. I had a client who once told me that if they were to comply with the notice provisions in their contract, they would never actually perform the contract. They would just spend all day giving notices, which they chose not to do. But that's a very dangerous position for contractors to take, because substantive contractual rights, such as the right to take certain actions or certain claims, may depend on compliance with these notice provisions. There are clearly project sponsors in Qatar who think this process, using essentially non-negotiated tender to impose onerous contractual terms on contractors, is a good process. The employer gets the best contract terms possible, and after all, the contractor does sign the contract and accept all the obligations and risk allocation. I don't see it that way. And I suggest that if parties into a contract, often with hundreds of millions or billions of rials in value, they enter into contracts with a lack of alignment between the parties and an inherent imbalance in the contract terms, they should consider on the last page of the contract, right below where they put their signatures, adding the following stamp. I apologize, I couldn't find one that said "see you in arbitration," but it's the same point. So I'll close by showing you what I at least think is a funny slide. Some of you may have seen it before because I've used it before. It's also not my slide. I was given it by Hill International, so if there's anybody here from Hill, I hope you don't mind me borrowing it again with full attribution. Can you read that? With going from top left over, this is how major parties to a project see the world differently. So the first slide is how the customer explained it. The second is how the project leader understood it. Then the analysis design, how the program wrote it, how the business consultant described it, how the project was documented, what operations installed, how the customer was billed, how it was supported, and finally what the client really needed. The point is that owners and contractors will always have their own different interests, and contractors within the consortium will always have their own individual interests. But the existence of disputes and resulting litigations and arbitrations all across the construction sector is increasing. And it's increasing also the costs associated with construction and delaying important projects. It's also having other negative implications, such as the exit from the Qatar market of certain contractors. So it would benefit everyone to see a reduction in construction disputes. I guess I should qualify that by saying maybe not the lawyers, but it would benefit everybody else, including the state of Qatar, to see a reduction in construction disputes. So at the start of my remarks, I stated my thesis that structuring relationships at the beginning of a project to align interests of the stakeholders as much as possible is the best way to avoid disputes or settle them when they arise. The positive examples I've given, and I appreciate it's a bit, apples and oranges, but if you look at the equity joint ventures in the energy sector, the use of project financing for development of projects, those all have the characteristic of thought going into the structuring of the project from the outset, stating the point sort of the other way around, entering into contractual arrangements that are unstable or imbalanced, and that heighten rather than mitigate risks, is more likely to lead to disputes, and to disputes that can only be resolved through lengthy and expensive formal dispute resolution proceedings. I hope I have had some success in convincing you of my thesis, and that there are practical steps that could be taken by both employers and sponsors to seek greater alignment of interests and mitigate the risks of stakeholder disputes. Thank you very much, and I'm happy to